Good afternoon, class.
Good afternoon, sir.
Yeah, good afternoon. I want to believe we are all doing fine. And I'd like to welcome you to today's class.
Good afternoon, sir.
Yeah, good afternoon. Good afternoon, class.
Good afternoon, sir.
Good afternoon, sir.
Good afternoon.
Good afternoon, sir.
Good afternoon, sir.
All right,
Good afternoon, sir.
thank you. So we started our class and we're looking at the various school of thoughts in addition to the various definition of law that we have considered and the efforts at looking at the various school of thought is to further enhance our understanding about the subject law. And today, by the grace of God, we'll be taking the lecture forward by looking at positive law school. Again, that was where we stopped in our last class. We are to start from positive law school. All right, so going by the postulation of the positive law school, this school of thought has defined law as what the sovereign says. Okay, that is the way the positive law school sees law. And while we were preparing to delve into the content of the various school of thought, our emphasis were to the effect that the various positions held by the school of thought is a reflection of their ideology, a reflection of their belief, and what they think law is. So if we are, to look at what the positive law schools have said, we will also definitely see the kind of scholars or individuals that this class covers. And from the definition offered, we will be able to know what exactly we stand for and their belief. So, and that's why in opening the conversation, we said that the positive law school sees law as what the sovereign says. But the question then, therefore, is to ask, who is the sovereign? Though, without minding or getting to know why they define law in that form, but of course, we will definitely see that as we progress in the course of this class. So this school of thought, which is the positive law school, define law as what the sovereign says. Anything that emanates from the sovereign is what law is. It therefore follows that for anything to be called law or to be valid by this school of thought, it must emanate from the sovereign. And I think when I was explaining this in the course of our last class, if we want to look at who the sovereign is in our present day Nigeria, we shall be talking about the government. The government is the sovereign, while the citizen will be considered as, the inferior being. So it therefore follows that what definition is given to law is not important. What is important is that it is what the sovereign says that is law, irrespective of the semantics, irrespective of whatever condition that has been laid down before such pronouncement or such rules were brought into being. So, and it can also mean, the school of thought also sees law as what the agent or the delegates of the sovereign. But what is key here is that the authority to make the law must come from the sovereign. Just like if the coordinator of this class is asked to carry out some instruction and direct the class to do some things, it will be based on the authority of the course rep that the coordinator will do whatever she is going to do. And then every individual that is a member of this class will be bound by the decision or the pronouncement that the course rep may make based on the instruction from the course rep. So it doesn't take away the fact that the instruction is from the lecturer or the sovereign. So in essence, it still boils down to the fact that law is what the sovereign says. So consequently, we can say then, therefore, that the Constitution, statutes, ordinances, and administrative regulations and rules provided by the sovereign must be obeyed without any form of question. So if it is given by the sovereign, then it is so. But again, when we look at what is prevalent in our society, they will say sovereignty belongs to the people. But the unfortunate thing is that in actual sense, it's probably the opposite. Because the only time you see our elected officers is when they are canvassing for help, for votes. Once they have been voted in, they become the superior or the sovereign over the people who elected them, of which, of course, it's not supposed to be so. It's supposed to be the other way around. But this school of thought concerns itself with the fact that once a sovereign has given a rule or regulation, that is what is law, irrespective of whatever it is that forms the reason behind the law. And we like to say that the positive law school is an opposite of the natural law school, because we did say that the natural law school deals with law as, made by nature, as having some form of divine or supernatural origin. But in this case, any law that is made by the sovereign is usually by human being. Consequently, they are man-made laws. Okay? So if we have that in mind, we know that positive laws are laws made by the sovereign, who are also human beings, as against natural law, which nature has, put in place on its own. Now, why the natural law school talks about what is right, what is just, the sovereign is not really focusing on what is right. It's not really focusing on what is just, but focusing on the desire to probably rule over the people that he has governed. That is the way this school of thought view law. Now, who are the scholars or the proponents of this school of thought? This school of thought is brought into existence by the contribution of the likes of Thomas Hobbes, John Austin, and Hans Kelsen. These are the proponents of this school of thought. The proponents are those who formulated, those who promoted this law that we are talking about. And of course, the definition or the description that has been given to law here is a product of what they perceive law to be. Going forward, this school of thought is also of the view that without positive law, the society will not be in order, that there will be chaos in the society, that the people will not obey will not do things that will probably be beneficial to the entire community. Meaning that if there is no positive law, then people will be free to do what they like. And then when you look at it, really, that in Nigeria as we speak, if we don't have laws, then we will probably be living in anarchy because people will choose to do what they like. Somebody can just wake up early in the morning and see the car belonging to his neighbor, and then we go ahead, take the car away from the neighbor, and then begins to probably rebrand it and put his name on it, and then we parading himself as the owner. But in a society where we have law, like Nigeria, for example, that cannot be done. And that gives us understanding of what the positive law school is saying, that without positive laws made by the authority, the society will live in chaos, without stability, without order, and there will be anarchy in the society. And then, as good as this may sound, as a matter of fact, some of us may begin to fall in love with the definition as provided by this school of thought, because it's like it represents what law ought to be in its sense, in the actual sense. But one of the things we do when we are making this kind of discussion is to look at the advantages and disadvantages that surrounds these various school of thought. If you recall, when we were looking at the natural law school, we looked at the weaknesses just the way we look at the strengths. We are going to do the same thing in this aspect of the positive law school. Now, these weaknesses include: one, the fact that the school of thought does not consider the political nature of the sovereign or the lawmaker. Well, that's one of the major weaknesses, and I will explain what that is all about. We are saying that one of the major weaknesses here under the positive law school is the inability to look at the political nature. Now, why are we saying that? usually a political leader who is selfish will give laws that will only favor himself and his cronies. So what we are saying in essence is that this kind of law, this school of thought, can eventually result to dictatorship. Okay? Because a political leader will want to take decision, especially a selfish one who does not have the interest of his people at heart, will definitely give laws that will be favorable to him. So that is one major weakness of this school of thought based on their view. Their view can easily lead to dictatorship. Then also, it can, like I said, can lead to dictatorship. And then we have uncommanded commanders ruling the society. And then that will lead to a situation where citizens cannot freely express their view or show their reaction when a particular thing is being said. Everyone will therefore require to keep short. And that does not indeed show or demonstrate a democratic society. Okay? Then the second weakness of this school of thought, the positive law school, is that it does not see international law as law, because international law is not made from a sovereign, but rather international law is made by a group of states coming together to make laws, which bind their activities and relations with one another. Nigeria is a sovereign nation. Same with the United States of America, same with France, same with Australia, and so on and so forth. So when they come together, it is not that one of the country will be issuing directive or rules to the others. No, it is usually a collective decision. So meaning that the position of the sovereign is not seen, because all of them will contribute equally. So that's why the positive law school does not consider it as law. Of course, it need actually not be so. It is not until a sovereign, an uncommanded commander, gives a rule or an order before a society can be governed properly. There are other, ways in which the society can live peaceably with existing laws made by the people and generally not by one uncommanded commander. So that is for the positive law school as a school of thought. And then the next school of thought we are going to look at, in the attempt to further define law or to understand law, is the historical law school. The historical law school. The historical law school of thought define law as a product of historic developments. Okay? The historical school of thought define law as a product of historic development. What they simply mean is that law is an outgrowth from the history of the people rather than an artificial contrivance, meaning that the life of the people usually should dictate what law is. Now, I give you an example here. Some time ago, a particular powerful country approached the Federal Republic of Nigeria during the time of President Goodluck Jonathan. And the president of that country requested President Jonathan to recognize the rights of homosexuals in Nigeria, meaning that if that is recognized, woman can marry woman, man can marry man, and then what happened? The President Jonathan then declined. And what were his reasons? His major reason is that such a life is not common to us as a people. It's not something that is part of our culture. So that's why the historical law school is of the view that the law that should govern the society should be the law that emanates from the history, from the culture of the people. And of course, practically 99% of those of us in this class, except those who belong to that special class, we agree with President Jonathan that gayism, lesbianism is not part of our culture. In the Western world, if a man and a man are going on the road, they can be calling themselves and they will not see anything wrong in it. But on our streets as Nigerians, if a man is seen holding a man more than necessary, all eyes will definitely be on him. The same thing applies to a woman. Why? Because our culture does not permit such a situation. So therefore, the historical law school sees law as an outgrowth from the history. That is, law is simply developed from the way of life of the people. And they believe that law is what binds the people of a particular society together. And it is also what distinguishes them from one another. The Igbo people of Nigeria have their culture. The Yoruba people, they have their own culture. The Hausa people too, they have their own culture. I do not know how true this is, but I heard that if an Igbo man marries or decides to impregnate a woman, probably from the same Igbo extraction, and then the woman gave birth to a baby for the man, and the man to date has not paid the bride price of that woman, we understand that by the culture of the Igbo people, that the children produced by that union cannot bear the name of that man because the man has not paid or has not fulfilled the requirement before a woman can be given to him as wife. And if that is true of the Igbo people, in Yoruba land also, you don't just carry a woman and then the woman becomes your wife. The law, the custom of the people require that as the man who wants to marry, you need to perform some cultural rites of either going with some items to meet the parent of the wife to be, paying some money, giving some gifts, and so on and so forth. So what we are saying is that these various cultures, as unique as they may be, they are the things that bind a particular group of people together. You will also agree with me that even in some culture, when you say you want to marry a woman and you pay bride price, at the end of the day, they return the bride price to you after they have accepted it. they will say that they are not selling their daughter, rather they are giving the daughter to the man as a wife. So why are all these very important? These are the recognized way of life of the people, and that's why this school of thought, the historical law school, believes that every law should come out from the way of life, from the culture of the people. And as a matter of fact, they believe that every law is also an offshoot of the society. So that is what the historical law school believes. Then who are the proponents of this school of thought, class? The proponent, that is, people that we refer to as exponent of this historical law school, include names like Gustav von Hugo is one of the experts in this aspect. Also, we have Carl von Signy as another exponent of this school of thought. The name again is Gustav, Gustavonhugo, and Carl von Signy, that is KARLVONSAVIGIGNY. That is the name of one of the proponents. So in your exam, you may have names, about 5, asking you and will request or require you to identify the proponent of the historical law school. Then also, to add to the submission we have made, according to this school of thought, before a law is made for a society, that there must be a good understanding of the history of the people. So as we go forth and back on what this historical law school is saying, we see that emphasis is laid on the history or the culture of the people. And the school is of the view that law must accord with the way of life of the people. If a law is made that does not accord with the way of life of the people, it may not lead to, it may prevent acceptance. And when there is no acceptance, the law will suffer from people obeying it. And that's why, if you look at the example I gave, that if President Jonathan has said, because of what we want to get from the other country, that agreed and made law, you discover that our society will fight against it. Because even though there are people who probably practice these things, or people that are even listening to us who practice this kind of relationship, we support what the decision, but majority of Nigerians, so to speak, do not see that as part of our life. So therefore, the historical law school believes that what is law is what came from the way of life of the people. An example of law that is based on historical law school of thought is the customary law. Each and every member of the Society of Nigeria, for example, have their own different unique laws that identify or that makes them to be unique one from another. Okay, then historical law school of thought also has its own weaknesses. The major weakness that has been attached to the historical law school is that at what point in time or for how long can the society practice something before it can become law? That's one big question for the historical law school. For how long are we going to be practicing something before it can become law? Is it 50 years? Is it 20 years? Or something that people start doing within a week? Will it become law? There is no way to ascertain how long a practice can be before it can be regarded as law in the society. That is the number one weakness of this school of thought. The second weakness has to do with the fact that the spirit of the people changes. Okay? Because as human beings, we change our ways of life, our operation at intervals. This kind of society we have now is different from what used to be in the 1980s. For example, the Igbo people, a lady got married recently to a very influential individual in the society, and the marriage took place in Lagos. And I read on the news that some people criticized them for doing what they did, that they ought to have gone to the east to do the wedding. Why? Because they believe that is when the wedding itself is proper. But the thing is that the times are changing. If that was the position as at that time, if the two couples are in Lagos now with their parents, and now with the cost of movement in Nigeria today, you now ask them to travel far away from Lagos to Imo State, for example, then they'll look at the cost and say, why do we have to incur this? Please, let's do it here. Thank God, there is Zoom. We can deploy Zoom for people in the village to watch what we are doing. The truth of the matter is that before now, that was not the case. It's probably that almost every wedding of the Igbo people, they will have to go to their village where they believe the elders are, where they believe the right thing will be done according to tradition. But the thing is that the times are changing. So this school of thought fails to address that when people change, what then happens to that particular law? Does it change, or will it lose its acceptability? These are issues that pertains to this particular school of thought. But as those criticisms, as beautiful as they may sound, the truth remains that the proponent of natural law school also have very valid point when they said that any law that will govern a society must be the one that comes from their way of life. Because if it comes from their way of life, it will ease accessibility, it will ease acceptability, and also help the people to obey them easily. So that is what the historical law school of thought has to say about our understanding what law is. Quickly, I'll move to the next school of thought, which is the realist school. R-E-A-L-I-S-T, which some call realist school of thought. Now, if you have your question, you can note your questions down or send the question to the Q&A section of this platform so that we can answer them together before we bring the class to a close. Now, what view does the realist school of thought have concerning law? This school of thought define law as what officials do about disputes. They went further to say that law is the prophecies of what the court will do and nothing more pretentious. That is the way they see law. Now, this may sound strange. This may sound unclear to some of us. That what is the school of thought saying? The school of thought is saying that irrespective of what is written in the rules, whatever the court says is what the law is. For those of us who were active, as at the time President Tinubu, I almost said President Oluwa Tinubu. When President Tinubu won his election, and the victory was being challenged, and they went to the court. The likes of Obi and Atiku went to the court, and they made arguments relating to the number of votes that an individual must possess before he can be declared winner of an election. They didn't just stop there also. The question as to whether the president or the person who will occupy that seat must win the Federal Capital Territory was also an issue in that case. And then they went to court, asking the court to invalidate the election of the president, of the elected president, because he could not win a certain percentage of the total vote cast in Abuja. And the court said they gave their own interpretation, even though what was in the laws that everybody can see is a different thing. But the court interpreted it. So this school of thought is saying is that it is whatever interpretation that the court gives that is law. And how does law, the court, govern the society? The court governs the society through what we call case law. By the time we'll be talking about sources of Nigerian law, we'll talk about case law, which are the decision that the court has arrived at or has reached in cases that have been presented to them. And then those judgments, those pronouncements have become law, which is now being applied in the society. So this school of thought believes that it is what the court says that is law, not what the legislature must have given in the process or as a product of their law-making exercise. Now, just like we look at the various scholars within other groups, other schools, we're also going to look at the exponents of this school of thought. And the exponents include the following. Number one, Justice Oliver Wendell Holmes. Justice Oliver Wendell Holmes is one of the exponents of this school of thought. Another one is Carl Lewley. The Carl is spelled K-A-R-L. Lewley is spelled L-E-W-E-L-L-Y. That is another exponent of this school of thought. Another school of thought is Jeremy Frank. Jeremy Frank is also another exponent of this school of thought. But basically, what their position is that it is whatever the court says that is law, not what the culture of the people is, like in the case of the historical law school. Now, the question then, therefore, is that what of the situations where what the court says is determined by some factors that are not supposed to be? For example, a judge who has been compromised to deliver a judgment, what becomes of such judgment, even though it's not a right judgment, but it has been influenced by one thing or the other? That is one major issue with this school of thought. But they maintain basically that in order to know what the law is, there's need to look into the statute book. I mean, that it is not looking into the statute book, but looking up to what the court will say. So, meaning that for the historical law school, who have heard that law is a product of the culture of the people, this school of thought says no. When you bring that culture of the people to the court, it is the interpretation that the court gives to the court, the custom, that is the law, and not what the society has presented to its citizen, that is law. Rather, the interpretation given by the court. Now, what is the major weakness or some of the weaknesses of this school of thought? The major weakness is that this school of thought focuses only on the court system. Because is the court a law-making body? The answer is no. But the school of thought expects that whatever judges say or what they do is law. Now, if I like to ask that, what influenced this kind of submission? The simple truth is that the people behind this kind of definition of law are judges. The realist school, that's why we made mention of Justice Oliver Wendell Holmes, who also was a renowned jurist, a judge. And that's probably what influenced the definition that was given by the realist school. The last school of thought that we are going to look at is the utilitarian school of thought. I hope you can hear me in class.
Yes, sir.
Okay.
Me too, sir.
All right. Thank you very much for the confirmation. Okay. So the last school of thought we're going to look at is the utilitarian school of thought. This school of thought is of the view that proper law is the law which promotes the greatest happiness of the greatest number of the society. I'll repeat that again. The utilitarian school of thought believes that proper law is that which promotes the greatest happiness for the greatest number in the society. This school of thought believes that, oh, yes, anything can be law, provided the majority of the people in the society are happy with it. That, oh, the law is good once the majority feels that it's a proper law and makes them happy. But if the majority says no, then it's not a good law. Though if we look at it from that angle, it's proper to say that, yes, the law must be generally acceptable That is, it must be one that we have general acceptance by the society. But of course, a law may have general acceptance and yet is not a good law. That is one aspect that we need to focus on when we want to look at the weaknesses of this school of thought. So, this school of thought believes that law made or enacted by the legislature must meet these requirements. That it must be a law that makes majority of the people to be very happy. That if a law is made and does not make majority to be happy, that law is not a good law. Okay? Then the question we ask is that the majority does not make up the society. What about the minority? What about the interest of the minority? That is one major issue with this school of thought. The fact that they neglect the interest of the majority. They are saying that once the majority of the people are happy, the rest is not important. This is the view of this school of thought. Who are the people behind this school of thought? We have Jeremy Bentham. Jeremy Bentham is one of them. And they also believe also that legislatures usually enact law in order to put pain and pleasure side by side. And then, pain and pleasure in what sense? If you want to live in the society, you don't want to be punished by the law, do what is right. The pleasure that is required of you is that you do what is right. If you don't do what is right and you go against the law will punish you. So this school of thought is setting as to what they believe law is. But in general summary, this school of thought that we have looked at, they have very valid points. Valid points. They also have their weaknesses. The question, therefore, is that which one of them is the best? But for the purpose of this class and this discussion, none of them is the least or the best. Each of these definitions were given based on the background and experiences or the views or the trainings of the individuals who have discussed law in the way that we have discussed it. So therefore, there's no better view in either the natural law school, the positive law school, the historical law school, the realist law school, and the utilitarian law school. Okay? There's no better view. None is entirely wrong or right. Against this backdrop, then, it is better to describe law than to try to define it. Because one of the things you will see is that every attempt to define law comes with weaknesses that can be pointed out as criticism. Okay? But it does not make them to be wrong or right in entirety. That's why we're saying that instead of looking for a definition that is perfect for law, law is better described than defined. But for the purpose of this class, we can say that law is described as rules and regulations that guide human conduct. and it is acceptable as binding by the society which it is given. So you can define law or describe law as body of rules and regulations that guide human conduct, which is acceptable as binding in the society and also enforced by the society. So with this, we'll have come to the end of the definition of law, starting from when we look at what the scholars define law to be as a foundation to this class, and also by looking at the various school of thought. So in all of what we have been saying, we can see that there is no generally acceptable definition for law, but it can be described rather than defined. So before we call it a day here, I do not know if we have questions relating to all that we have discussed. Any question so that we can do justice to that before we call it a day? The floor is open, please. Any question? Okay. In the absence of questions, we will call it a day here, and we meet again on the next adjourned date.
Hello, sir. Yes, sir. Hello, sir.
I will quickly say that I take this course in other departments, and like I sent the link to your class rep the other time. If when we are taking those lectures, you are free, you can join the classes, listen to what we have to say, so that when those classes are already ahead of this class, so that when we are teaching that topic in this class, it will look like a second lecture for you, and it will also aid in your understanding of what we're talking about. So I'll keep on informing your coordinator to carry you along. Yes, someone wants to ask a question.
Okay. Hello, sir. Please, can you help send the PDF of this today lecture? Because I look at the content of the course, I couldn't find this today's lecture on it. I mean, the school of thought. So,
how many textbooks do you have on this course?
I only have only one module, that GL 111.
How many textbooks do you have on this course?
I don't have any textbook, sir.
Go and buy textbooks. The recommended textbooks are in the scheme of work that I gave to you. You will not see all these things on the road. You will see them in books.
Okay,
so
sir.
the era of lecturers giving you notes or spoon feeding you is over. Go and buy your textbooks. These lectures are in those recommended tests. Yes, that was you.
Good afternoon, sir.
Please go ahead.
Yeah, please, can you just take us back to the exponent on the Can you hear me, sir? Sir.
Can you send your message to please send your message? Please send your question to. Okay, you can ask your question. I thought you were the one close by the mocks and then you are asking question. Yes, Mr. Adisa Wasiu, what's your question? Okay, it's all right. I know you have another class almost at this time. So we call it a day here. See you on the next date for this lecture. Thank you very much and enjoy the rest of your day. Bye.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you,
Thank you,
sir.
sir.
Thank you.
Thank you very much, sir.
I really
Madam of
enjoyed
ask
this.
question.
Thank you, sir.
Thank you, sir.
Madam of ask question.
We appreciate, sir. Thank you, sir.
After them of the ask question.
Please, for those that have the textbook or the name of the textbook, please you can share it with us because I can't really find out what is it. They are saying the module sent to the group.